May I please? I beg to mention item number 7 of today's list. Any adjournment? The last thing I want to item number 7.
Okay, yesterday it was circulated. Your name?
Jay Sinha.
Jay Sinha. With consent of the other side, Mr. Jay Sinha, counsel for the petitioner, prays for adjournment. Prayer is allowed. Please start her. 2 weeks.
14 and 50 he will be in Mizoram. So after that, 3 weeks will be good.
14, 15, not here. Okay, week commencing. You said list on 18, 2024. Okay.
Obliged.
Maybe your lordship.
Yes.
Lordship, item 6, it is listed today as well as tomorrow. And since lordship today, I suppose the Mia cases are there, I'll do it tomorrow, lordship. It is
No,
listed on both
even
the-
tomorrow may not be possible.
Okay.
Yeah, it will go to next week and thereafter. Okay. All these matters you
Then I
Make it
don't have to
after.
mention.
after 2 weeks, make it after 2 weeks.
And tomorrow again, I have to mention or what, lordship, because it is listed again tomorrow.
Because tomorrow's the day I can't pass today.
Yes, that is what, I'll look at it tomorrow.
Yes.
But that-
And there's all saying, tomorrow is another day.
Yes, yes. How beautiful. Hello, bye.
Yes.
In respect of item number 3, can I?
These will all be adjourned. We'll give a date after 2 weeks.
Public.
Part had one, that may be same.
2 weeks. Because I proposed to this pattern matter, I proposed to do it early. Because if I distract, neither this will be over nor this can be completed. Because we are deep into it.
Okay.
And this is a case, I think, where not for you, but for young lawyers, they should be here and observe the matter. There are many things to learn. Yes.
Supplementary item 8 weeks 9 for orders.
This is
Yes.
that matter where the objection was not on record and it got postponed, I think twice. Today the council has some problem.
Why being Mr. Sarfraz Nawaz is annual today? Being Council Mr. Sarfraz Nawaz is annual today, Lordship.
Okay.
We are seeing 1 day accommodation, Lordship.
No, it goes next week.
Next week.
Next week. Uh, We'll fix it on 4th or 6th. When do you want?
Subject to convenience, Lordship, when it is.
Okay, then 4-6. Sorry, 4-3.
The other analogous matter will also follow. Four.
Not with regard to the other matter, madam. Just a small submission, the applicant matter is not keeping well, madam. With regard to that matter, I also have filed an additional affidavit, madam. Madam, in the meantime, can I report maybe from the jail authority with regard to the present health status of the applicant?
Otherwise, he
Wow,
is the
what
main
is-
perpetrator.
What is the illness?
Madam, heart blockage. Madam.
Which item?
My lord, 9.
No, case number.
My lord, 270 Higher criminal 507.
507, last file.
Page number 21.
It's not there. It's not attached. In Primla P217, right? The counsel for the applicant submits that an additional affidavit has been filed to bring on record the medical condition of the applicant. So it is submitted that let the same be brought on record. Next, in the meanwhile, the Ms. S. Jahan and APP
I'll get a
shall
medical.
obtain the medical status of the applicant Nasiruddin Sheikh as alias Nasir. From the concerned, from the superintendent of the concerned jail where he is currently lodged. Next, the learned APP is permitted to send a downloaded copy of this order to the superintendent of jail where the applicant is lodged.
Anyway, I'll get a report.
You see, we were compelled to open this paper book for a reason. You have a copy of paper book with you?
In my case, I have the paper copy of the paper.
Okay, you have a copy of paper book? No.
Sir,
You see, as per the paper book, this Nasiruddin actually is Nasur. His age is 24 years. So we are hard to believe that he will have a heart blockade.
and he was the main perpetrator.
No, we don't know about that.
Yes.
We are not evaluated, but once he says there's a heart blockade.
Happy nowadays,
But
even young
before he
people
was
are.
taken into custody matter, he did a medical in the year 2022 itself. The report which I have annexed, my lord, is of the year 22. Before
This
he was
shows,
taken into
this
custody.
shows that.
I submitted the affidavit last year itself.
Let's see. Here is 51 years.
Yes. But surprisingly, my lord, when I check the 313 statement, there, my lord, in the year 2005, it was recorded. There, my lord, the age of the applicant was recorded as 24 years.
Poor recording.
24 years. But I verified but probably my lord, he was major at this point of time when the incident
No,
occurred.
that's okay, but 24 years and 51 years, this it creates a doubt.
But in the year 2005, he was 25.
20,
Now he is
2005.
51. His photograph is annexed, my lord, at the last page.
Because when it comes to illness, we have learned a lot from one of the politician in Bihar. I'm forgetful of names. I don't remember it so easily, but he hardly served sentence. He was all throughout in Bihar, in hospitals, in Ranchi, in Patna. I learned a lot of things from him.
Even a doctor will show the age that the report comes.
But that's okay, but still do it. Once it is left ventricle hypokinesia, we'll have that report. Then we are fixing it on Wednesday,
6th, madam.
6th, not on 4th. 4th, it may not come.
Sixth. Gotcha.
Highly hope.
You give a soft copy of your this IA to her. She can mail it. Otherwise, they may not be able to. What do you call? Jails have some limitations in diagnosis. Soft copy, give it to her
I'll send it to
by
you.
tomorrow. Ms. Jan, should I mention it in the order also so that it is easier for them to take it from you?
Gotcha. Send me
That-
copy
ha,
whatever
ha,
he has given. Lodge, yeah,
The
and send it to me.
counsel for the applicant shall provide a soft copy of the interlocutory application and additional affidavit to the learned APP so as to enable her to transmit the medical, the same to the superintendent of
Yes.
concerned jail.
Gotcha. Okay.
Supplementary item 10 to 22.
But Mr. Mishra, we have to lodge a strong protest against you. Very strong protest. Your assisting counsel was intimidating us. He was carrying a large file and I saw him. So that is intimidation.
they may not be aware.
Huh?
They may not be aware of what they are doing. We did it much long ago. This was. And today in my reply,
No, because we had those experiences then when you put up stacks, then the matter gets adjourned. So,
so it happened to some. Not all the way. Yes. Today, something I remembered of those days when I was arguing roller and flour mill case. The roller and flour mill case. I think you'll remember. There the word deeming provision came in. And there were a lot of argument on deeming provision.
Article 265. Article 265, a man wearing a sari.
That was in context of a tax matter which was in, and there was something, but this is, if you remember, Article 286 earlier, now it is repealed. It is repealed, it was repealed after Bengal immunity case, where the word fiction was made, and on the basis of that fiction, even if the sale is not taking place in a state, the delivery state used to write to the dealers of other states to get themselves registered. And Bengal Immunity was a company of Calcutta, West Bengal. They sold something and it was delivered in Bihar. The Bihar Superintendent of Police wrote to this company at Calcutta that your materials have been delivered in Bihar, therefore you will get yourself registered because you will be entitled to pay sales tax. And there were two earlier decisions of the Supreme Court, Constitution Bench, which says yes, it can be done because of Article 286. In some other cases, my lord, I will show. Then, my lord, it was referred to 7 judges case. And the judgment is by S.R. Das. And there, this 286 was interpreted. That this deeming provision is a legislative device by which they assume something and so that it can be brought to the logical conclusion. I'll hint it, I'll not go into those things, but one such thing is there here. Then, my lord, I'll begin and I'll try to finish it today. Tomorrow I'll have to do for some social thing. Well, at first, I'll reply to the argument that was placed by my learned friend, Mr. Dilip Das. This was on 19-2. Date-wise, his argument, I'll refer. So his argument on 19-2, I'll be replying with it.
Nine.
Well, my learned friend first referred to first information report that I'm not going to go into it. It is there. Then he referred to PW 3 and 4, who are the protected witness. They are not concerns. In respect of the accused, on behalf of whom I have been instructed to appear, that is A6, 8, 11, 15, and 20. PW 24.
A6, 8.
8, 11, 15, and 24.
Yes.
So I'll not say anything on 3 and 4. Then my learned friend referred to section 20 of UAP Act. And he tried to show your lordship that only membership is punished. Section 20. And to my lord, buttress his claim, he referred to Khwaha Fasal's case, which I also referred, and he also referred to paragraph 10 and 11. If your lordship can take up paragraph these, compilation 3, I have annexed this. All decisions, even they have given that I have annexed, I have made another compilation. Your lordship will get 5 compilations, but everything is there. Annexures, the exhibits, and the decisions that they have placed, your lordship will get in these 5 compilations. If your lordship will take up the compilation number 3, compilation number 3. Page 87, the case starts from that page.
Paragraph 10.
Paragraph 10 and 11, I have already referred these 2 paragraphs, and even my learned friend also referred these 2 paragraphs. Now, what he is inferring from this paragraph and what I am inferring from these 2 paragraphs, that my lord requires your lordship. Now, your lordship has seen section 20. It has 2 components. Number 1, accused must be a member of a terrorist organization. And second, the terrorist organization must be involved in some terrorist act. It is terrorist organization which has to be involved. That is the requirement. If my lord can take this, I'll take again compilation number 2. While my lord, compilation number 2, this is UAP Act is there. Page 30 relevant. From 1, page 30. Any person who is a member of a terrorist gang or terrorist organization which is involved in terrorist act. Now this which is applicable to not the person, the gang or the organization. And your lordships are aware that legislature cannot be assumed to have used even a word unnecessary. This is a presumption which your lordships have laid down. So it will be presumed that legislature intended to provide 2 components in section 20. Number 1, one must be member of terrorist organization. Second, such terrorist organization must be involved in a terrorist act. This is what distinguishes section 20 from section 38. If my lord remembers, 38 is also punishment for membership. In fact, it's a specific. Your lordship may kindly have
10 years.
10
10 years.
Yes, but this is also punishment for being a member who, my lord, promulgate or uh, who associates, professes or to be associated with a terrorist organization. At page 18, your lordship will see the difference between the two. 20 and 38. Both deals with membership. So therefore, it is not correct interpretation. It will not be correct interpretation of section 20 that only membership is enough. Then if that is enough, then 38 should not have been punishable with only maximum, I think, 10 years.
Up to 10 years.
Yes, up to 10 years. So that is maximum, can't go on 11 years. But that is, it can be even life. And I'm surprised. Mr. Das, my lord, my learned friend, referred to Basir Punnu's case. Basir Punnu, it goes against him. It demolishes the argument that he has set up before your lordship. I have a next at page 1 of the compilation 5, the new compilation. He's there. If lordship has these 5 compilation, lordship do not have to go and look into the others, except for the judgment. Fine. But you know now, Manu. Manu. I'll submit in detail about this because he has tried to say so many things on it. But for the present, your lordship will kindly come to page 24 of the compilation.
20?
Same case continues up to 25. Your lordship will come.
That Pannu's case.
But I have annexed it for your lordship's convenience because if it is not at one place, it's difficult to find out papers. So I have annexed it. Page 24, if your lordship kindly come to. The quotation of a different case ends at paragraph 92, just below that.
Just yes.
Just below the 92, up to 92, is a quotation from other case. Just below that, if your lordship will see. Thus, all the 4 respondents, that is Basir Ahmad Pannu, Fayaz Ahmad Loon, Abdul Mazid Baba, and Sahid Rafoor, having acted as member of terrorist gang involving and facilitating the commission of a terrorist act. So 2 components, 3 heroes. Otherwise, section 20 will not come. Now, in this case only, while referring this case, my learned friend Mr. Das took your lordships through paragraph 38F. Your lordship will get at page 23. 38 is that it starts from page 20 of this case. And the relevant is at page 23, F, which is he placed before a lordship. I'll place it. Page 23 of the same compilation type. So in the present case, there is no material evidence before this court to show that the respondents are member of the terrorist organization. However, from the acts of the respondents, which have been proved beyond reasonable doubt, it is evidently clear that they can be termed as member of a terrorist gang or group. A division bench of this court, in decision reported in so and so, considering a paramateria provision of 3.5. 3.5 was like 20, 3.5 of Tata, I have taken it.
Tada.
Of Prevention of Terrorism Act 2002 held from the conduct, that from conduct, nature and quantum of recovery made and the interaction of A2 and 3 therein with A1 without doubt makes them member of a terrorist gang involved in a terrorist act. I'll place only this, then the other decisions are. Here the case was that they say they are not member of a terrorist organization. And that was correct. But it's not terrorist organization only. It can be also a terrorist gang. And terrorist gang, your lordship have taken through, is defined under section 2M. And any two, more than 2 persons can gather and do anything. They will be member terrorist gang. And even otherwise, for the purpose of section 16, even a lone person, he goes and throws a hand grenade, he'll be charged under section 20 for it's a terrorist act. So, but to say that from conduct and nature and quantum of recovery, it can be referred that he is a member of a terrorist gang. Now, they are not saying that we are member of a terrorist gang. They say we are member of a terrorist organization. This is the difference. And moreover, your lordship will see what was the facts of the case. Because a case, your lordship decides a case on the facts. The law or the judicial precedents are used on the facts of the case. Let's see the facts of this case here, where the facts are similar. Your lordship will kindly come to paragraph 2 at page 1. Now, I'll just place my note from 3 lines from the bottom, but before that, I'll just summarize it. An information was received that arms and ammunition will be delivered and it will be used for terrorism. And therefore, the raiding party was made ready. Now, I'll read from 3rd line of from the bottom. A raiding team was constituted. Last 3 lines at page 1. A raiding team was constituted and it was found that Bashir Ahmad Pornu, alias Maulvi Fayyad Ahmad Lone and Abdul Majid Baba, who came by Malwa Express, met Sahil Kapoor and passed on the consignment. When they were apprehended, Bashir, Fayyad and Abdul were overpowered. However, Sahil Kapoor tried to run away after firing on the police. Officials, thus cross-firing ensued in which none was hurt. Finally, Kapoor was apprehended and PETL explosive, timer and non-electric silver colored detonator hand grenades and 100 notes of rupees 500 currency was recovered with influence. It's a different facts altogether. Your lordship will see in paragraph 6, paragraph paragraph 5. I'll start from last 3 lines at paragraph page 2 of paragraph 5. Team reached New Delhi station. Third line, that's the team reached near Delhi station Ajmeri Gate near Wimpy Restaurant at about 6:35 p.m., where they met the secret informer. Malwa Express was to arrive at 8:30 p.m. at the platform number 6. 7-8 passers-by were requested to join the raiding team. However, none agreed except one, namely so-and-so. Part of the team took position near the stair of the overbridge at the platform number 3, and part of the team deployed at EDU market so-and-so flyover. At around 9:05, Malwa Express arrived at platform number 3 and passengers alighted from the train. At about 9:10, the informer pointed to these 3 passengers, out of which he recognized one Basir Ahmed. All 3 of them came out of the station from Ajmeri Gate side, where Bashir went to STD base and made a call. The team members secretly followed all the 3 members of them. Inspector so-and-so in the meantime found out the contact number where Bashir Ahmed had made a call. He was informed that Bashir Ahmed had made a STD call at a JNK number. After making the call, the 3 started moving towards DDU Mark so-and-so and reached the bus stop at DDU Mark near Ranjit Singh flyover, where persons having black color bag on each shoulder was already present. The said Basir Ahmed met that person, checked the cardboard box. After opening the same, immediately the raiding party asked them to surrender, disclosing them their identity. The person who was present at the bus stop and to whom the cardboard box was handed over, whose name later was revealed as Sahid Kapoor, resident of Pakistan, left his bag and cardboard box on the footpath, took his pistol, started to run towards IPO while firing on the police party. The police party retaliated. In the meantime, other 3, Basil Ponnu, Fayaz Lone, Abdul Majid, were apprehended by the members of raiding. The team side took position behind the tree situated on the way of Arya Samaj Mandir at DDU Marg and fired on police, and after 5 minutes firing stopped, and then the militant was asked to surrender, in which he threw his pistol on the way and came out from the backside of the tree when he was overpowered. Where is the comparison between the 2 facts? They have not produced anything. Not a knife has been produced. My submission will be minor. Before placing the case, one must look into the facts of the case and also what law was laid down. The case was that they are not member of terrorist organization. The court said so what? Terrorist gang, more than 2% will form a gang. Then he says that insofar as his explanation is bizarre of the second part of section 2.
I hope you're not targeting here.
Like this. Like this. The second part, that which is involved in a terrorist act. He says those who are involved will be dealt with under section 16. Section 16, anybody. Section 16 doesn't say terrorist organization or terrorist gang. Section 16 opens up whoever. So any person can be charged. So therefore, this decision is of no help. Rather, it's self-contradictory. Then, my lord, my learned friend, my lord, read out PW 17. PW 17, my lord, he read out. And there he says that in the month of August, he talked to A6 Rakesh and informed him that he is going on an official trip to China, and Rakesh, and he will be on the in Bangkok on the 1st of August. So A6 allegedly informed him, I'll also be in Bangkok. So they met there. And it is further alleged that they met A19 also came and met them. This is the statement of A16. I've already placed, need not, will not again trouble your lordship. Now, they have not, well, if this is the case, then I'm not advising what should have been done. But normally what is, in order to prove this, because everything has to be proved, nothing can be presumed. Presumption is only available under section 43E of the UAP Act. That's the only thing where you recover arms. Just take a lot into that. The other day also I have taken paragraph 43, my lord, will get at page 21 of compilation 2. This is the only thing which can be presumed. 43E. In a prosecution for offense under section 15, it is proved that the arms or an explosive or other substances specified in the said sections were recovered from the possession of the accused, and there is reason to believe that such arms or explosive or other substances of a similar nature were used in commission of such offenses, or that by the evidence of the fingerprints of the accused or any other definite evidence suggesting the involvement of accused in the offense were found at the site of the offense or on anything including arms, vehicles, used in connection with the commission of such offense, the court shall presume, unless contrary is shown, that the accused has committed such offense. So this is confined to 43D. And therefore, what was required to be done, or anybody would have done it, if evidence, the witness says that he was with me in Bangkok, we were in so-and-so hotel, find out which hotel you were. You go to Bangkok, find out which hotel they stayed, prove it. One says, hey, we met. That is not sufficient because the other denies. And there is another factor to it. My lord will kindly take PW 39 for a minute. PW 39 is compilation 3, if you lordship, compilation 3 at page 49.
Page 39,
49.
49.
This PW 39, my lord. Robert N. Robert Singh. And even 2 lines are at page 50. You see, this is in chief, then 2 lines in cross. Second para at page 50, my lord will look into. I, along with Rakesh, did not you get? I, along with Rakesh and many others, went for a visit to Vietnam to attend Northeast India Summit. When we returned, we stayed at Hong Kong and also at Bangkok. We went with not only 39, there was a delegation. And your lordship come to cross on the same page. Same page. Our visit to Vietnam was sponsored by central government. Project to attend Northeast India Summit. Rakesh A6 was sent to Vietnam. On his way, he stayed. They're making stories. They should have said that this is his passport. Apart from this, again, he visited also date.
What is the name of A6?
Rakesh,
Rakesh.
I'm up to his case. That is the main case.
Two 16.
Your Lordship has seen. And your Lordship will also see the passport which will come. It has not come, I have not seen. Then the other, my lord, part of the statement that my lordship referred was that there is some connection or some understanding between accused number 6 and 19. Why? Because he told A15 that UNLF sponsors candidates. Not all that, if PW17 is to be believed, PW17 said that I wanted to go to attend something in Dole Foundation. And Rakesh said that sometime they offer. These are a casual conversation. Then he says, I had written a letter handed over to Rakesh, but I did not receive anything from UNLF. Meaning thereby, the address he has given is his in that, not Rakesh's address. Rakesh was a postman. These, as my lord, I have submitted earlier before your lordship. PWs 10, 9 and 17, they used to visit and meet. I'm not saying for any other purpose, but they were writing some books. It has come, conflict.
We have had political leaders in this state. They make recommendations but use different ink. The concerned officials know which ink indicates what.
Yes.
So every recommendation has a story behind it.
Then, if at all you are exploring, investigating whether actually UNLF sponsored some candidate, you investigate. Did you find out a single person who was sponsored by UNLF? Or PW17 said that it has been taken as a gospel truth? My lord, in my humble submission, these are no evidence because they have taken these 9 and 17, having come to know that they are visiting, and they are not visiting for any other purpose. They say it's reserved. I was writing some books, PW17 says, and I needed some guidelines. Another thing I can tell you. insurgency in the northeast, which I have seen, and I have seen from very close quarter, in nineties, when Justice V.K. Khanna was Chief Justice. So he and Justice Patnaik, they will sit together. And I had so many habeas corpus matters, all of NSCL. No, wait, for them. Now, backhand talk is always on. There is backhand, otherwise there is no question on negotiation. Feeders are sent from both sides. That is how they come up. And NSCL is of course negotiating still with the government of India. They have come out. Even SCA also was part of negotiation, but then they unilaterally, my lord, resigned from there, and after they were added as a terrorist organization initiative. So somebody says that, yes, Rakesh says that sometimes they sponsor. So that becomes an evidence there is some connection. The connection is for what? For committing terrorist act or for waging war against the country. So I humble submission with me, my lord, that these statements cannot be of any help to the prosecution unless they investigate and find something more. And connection must be for committing an offense. Not that, yes, that day he was wearing a red shirt and you were also wearing a red shirt. Therefore, there is connection, there is some connection, there is some link. Criminal cases are not dealt with in such manner. There must be proof. There are decisions which says may not be, is not correct. It must be. Evidence must speak of the crime, must be a witness to the crime, the witnesses. You cannot say, no, maybe he has committed. No, you have to make out a case where you can say, must be, it has been committed. And kindly see, my learned friend did not reply. PW 17 met A19. He himself, it's an admitted position. In August 2009, after a month, he again met in 2009 in Kathmandu. Then again in September 2010, I've taken your lordship, your lordship must have noted. 9 and 17 both went alone. 17 was not, 6 was not there, and met A19. Now, meeting A19 will not expose anybody to an offense under UAP. Otherwise, they are meeting him 3 times. And they only say, one time I have taken, so I have link and they don't have link. Arrest them also, prosecute them also. Another admitted position is another admitted position is that But, I have annexed PW 17(9) in, compilation 3. So lordship can come to 46, page 46, PW 17. That's one line I want to show from here.
Page.
46. Compilation 3. You also will see fifth line from third paragraph. This is the statement attributed to A6. He told me that sometime UNLF is sponsored for academic purpose. Now this is being made as if I'm a member of UNLF. Then your lordship will remember. Then your lordship will remember PW9 made a statement that is the last of his cross-examination. That A19 and he both are from the same village and he knows him from childhood. This is the last part of, he did not say a word on this. That there was acquaintance between 9, 7 and 8, 19. And because of that, they have given evidence against me in order to save their own skin. Then, my lord, I have pointed out paragraph 70 of the judgment in my argument. Paragraph 70 of my judgment. The lordship has made a note when I was arguing. PW9 has stated that his sports coordinator and another person, Rakesh, A6, came to me and said our journey can be extended to Kathmandu for a day. Learned trial court says Rakesh came to him and asked him the journey can be extended and that the entire expenses will be borne by him. So they was changed for he. That I pointed out to your lordship. There was no argument on that. Then, again I'm repeating, 9 says that they came, Rakesh and 17 came and said our journey can be extended for a day. So they were going from Guwahati to Kathmandu. But they were going by a chartered.
Just come to that part again. PW9, show us again.
Lordship will come to page 41. Page 41. Addition 3. Towards the middle, 10th line exactly from bottom at page 42. Lordship got it.
Hmm.
Our university authority graciously agreed to our proposal and gave us official leave for 4 days, from 14th to 17th September 2009. But in the meantime, my course coordinator and another person, S. Rakesh Singh, proposed that we can extend our journey for a day to Kathmandu, and that they will bear all expenses. So they will bear all expenses. I agreed to their proposal.
Yes.
Because going to Kathmandu was something like dream come true, as if you were going to Switzerland. But again, later on, after some days, they revealed that we are going there to meet the chairman of UNLF. If your lordship will see here, the word used is they, both. Now, if your lordship will come to page 984 of the judgment, paragraph 17, volume 5. Part 1, volume 5. Nine eight four, third line from top.
Just opened.
I'll please 70. 984, third line. He further deposed, talking of 17, that S. Rakesh Singh proposed that the journey be extended to Kathmandu for 1 day. Your lordship has seen, he says, my course coordinator and
Coordinator.
another person. Be extended to Kathmandu for 1 day, and the journey of expense would be borne by him. And you see, there's a lot of difference, as if he is eager to take it. Then, my lord, if they have gone to Kathmandu for a day, then I believe they will have to charter a flight. Then only can go. Otherwise, they will have to go either by public transport, maybe air. They will have to go to Calcutta. There is no direct flight from them. How they have gone to Kathmandu? If you are banking on that, my connection with A19, if the prosecution is banking on these facts, they should have found out where I stayed in Kathmandu, whether we three stayed together, in order to, my lord, to substantiate what is being said, but they have not done anything. Nothing was done. Then, my lord, one submission of his Yes. One submission that really surprised me, my learned friend saying that it cannot be, a terrorist organization cannot be expected to maintain a sub account. Because then he says, there cannot be business in crime. Says that. I was kind of thinking, when did I say this? I never said. What I said was, the books of account of Duke East Nirman. Partner, it's a partnership firm of which PW39 is a partner. And exhibit 91 and 92 is not books of account of UNLF. This is books of account of the firm Lucas Nirman of PW39. Where is that question? And then a fantastic explanation has later come from the prosecution side that PW39 did not maintain an account for his own safety because A6 may say, I have not invested. So therefore, he did not maintain. But 17 lakhs they have taken from the bank. It's in the evidence of PW39 that SP Pani asked him to withdraw the money from the bank and produce in cash. This is fantastic explanation because the entire money is going to the bank. It is very difficult for any person to absorb 1.76 crores which he received and invest in his company without making any record of that and showing it in the income tax. I remember a few years back, my colleague, Mr. Khatonian, was issued a notice from income tax that from where you have received this money, the fee we show. He said, I don't remember. And he receives more than 1 crore and says, I have not entered into my account, but it is in your bank because you are giving the alleged profit from the bank. And then they said, this money is extorted money. This is what Mr. Dalip said. What is the evidence that these are extorted money? On the other hand, PW39 clearly says, Your Lordship will see that this is his personal money. PW39, if you believe your witness, you believe that part. 39 is at page, 39 is at page 49. 49. Page 49. Relevant is at page 50. Compilation 3 minutes. Okay. The Lordship will come to page 50 of compilation 3, the statement of PW 39. The last two lines, there is an admission that invested personal money not related to uniform. You believe in your witness. What basis you are saying these are extorted money? Absolutely no evidence, my lord. Then, my lord, I am surprised. He placed before your lordship Jahur Ahmad Shah Watali case. That I have annexed at page 26 of compilation 5. But I have just annexed the relevant portion which he has referred. At page 26, if your lordship says, the relevant paragraph 52 is page 27. Relevant is paragraph page 27, paragraph 52. I'll just place 2 lines. It will not be relevant at all, but he has placed, so I'm replying. Lordship, 52. The first 3 lines. Learned Attorney General relying on underlying principle in Khode Distillery and State of Karnataka would contend that there cannot be business in crime as such 34 of evidence and we will have no application. This is what he said. Now, this is saying, as if I have said, that you have not produced the statement of account of the UNLF. I never said that. My argument is that there must be balance sheet of Look in East Nirman, which is doing such large contract. And then their balance sheet must have shown or ought to have shown that I have invested so much money. The balance sheet must show in that context. But this takes me to a very interesting part of the submission. He may not know, I'm saying with all certainty, Mr. Das may not know in what context in Khode Distillery this sentence was, my lord, placed that there cannot be business in crime. My lord, there were 3-4 constitution bench decisions. And these are all related to prohibition, dealing in liquor. The first decision was one Hoover v. Varucha. That was 1953. There the constitution bench said that there cannot be a fundamental right. Nobody can claim fundamental right to deal in that. Your lordship is well aware. There are other decisions also, including that of Khode Distillery. So the judgment is by BP Jeevan Reddy in Khode, if I remember correctly. This was when this matter came up before another constitution bench of Supreme Court in 1967, K.K. Narula. versus state of Jammu and Kashmir. KK Narula case, my lord, very interestingly says that if the law prohibits dealing in liquor, dealing doesn't cease to be a business. So therefore it's a business and then there is fundamental right. That's the only decision, my lord. And in Khode it is mentioned in paragraph 54 that all constitution bench said no, it is not, no one can claim fundamental right to deal in liquor except this. So in that connection, my lord, in Khode, they said that suppose there is a prohibition. If there is prohibition, no one can buy drinks, no one can consume drink, so everything is prohibited. If anybody does it, then it will be an offense. As in Assam, my lord, there used to be, I think still there, I don't know if it is repealed. The Assam. It is still there. Still there, section 3. That's complete violation. Anybody found in possession of drink, he can be prosecuted. So in that context, it says that the comment in Narula's case that even if dealing in liquor is prohibited, the dealing doesn't become, does not cease to be a business. So they say there cannot be a business in crime. In that context, it is said. So if you had read it, you would have known. Now, my lord, paragraph 50, unfortunately, he has not enclosed paragraph 54 in Khode, though we have five. Lordship, by the time you will give the books, your lordship will take compilation 5.
Yes.
Compilation 5. Your lordship will get relevant portion of the Khode at page 34.
Yes.
My lord, paragraph 60. Your lordship will see. Paragraph 60, my lord, at page
Yes.
35. We may now summarize the law on the subject as culled from the aforesaid discussion. Your lordship will come to B. Right to practice any profession or carry out any occupation, trade or business does not extend to practicing a profession or carrying on an occupation, trade or business, which is inherently vicious, pernicious, and is condemned by all civilized society. It doesn't entitle citizens to carry on trade or business activity which is immoral, criminal, and in articles of goods which are obnoxious, injurious to health, safety, and welfare of the general public. Less extra commercial, there cannot be a business in crime. In this context, this is said. Therefore, so far as my submission is concerned, that Lucist Myanmar ought to have maintained a books of account, and the state, their books of account, their balance sheet ought to have shown that they have received so much money from Rakesh as he has invested. There is nothing. If I not see just 54, I think it is coming on your screen. 54. I hope I was 54. Just first 2 lines. That's all. It will thus be obvious that all the decision except the decision KK Narula have unanimously held, as shown above, that there is no fundamental right to carry on trade business in potable liquor sold as beverage, etc. This is the only case. And it is also a constitution bench.
So essentially what I consume is permissible here. One can consume ghee. And therefore, there's a fundamental right to do business in ghee.
I'm doing it, that's how I know. There the rule is challenged, made by Meghalaya. And there they are referring to this case. So that's how I studied that, I know. Now, my lord, out of blue, my learned friend has said, they are sleeping model and they strike when necessary. This was my. I will only, my lord, reply to that. I will only say these are drawing room gossip. They are sleeping model, they strike. Am I a sleeping model? Is it relevant in this case? My submission will be no. It's absolutely out of blue you are saying such a thing without any evidence on record. Then I'll come to Sarwan Singh's case. The Lordship specifically asked because here the proposition in a civil case, 61 Calcutta, was brought in here. My lord, facts of this case is that the FIR was lodged by one Darshan Singh. He had 4 brothers. Mukhtiar Singh, Pyara Singh, Sukha Singh and Mohinder Singh. There were 5 brothers, including the informant. Now the case of the prosecution is that on 12/10/1990, that was, if the Lordship remembers, peak of the terrorist acts in Punjab. That was the peak time. Nobody used to go out of their house from afternoon onwards. That was the peak time. And the allegation is that at 3 o'clock in the morning, 2 accused persons, Sarwan Singh and one Bagicha Singh, they came, knock at the door of Darshan Singh. They took away Mukhtiar Singh. Pyara Singh, it's not clear, but Pyara Singh perhaps was taken earlier. Both the brothers were taken out in the field, and then Darshan Singh heard the sound of fire. And after about half an hour, Mukhtiar Singh somehow reached his place. He was injured. And then FIR was lodged, and he was treated and all. So here, Mukhtiar Singh was not only an eyewitness, but also was an injured witness, which is, Your Lordship knows, very dangerous. It's not, normally his statement of an injured person who is an eyewitness is accepted. The defense set up by Sarwan Singh and Bagicha Singh was that no, there is enmity. And it appears that they did not give any, it was perhaps an admitted fact, not very clear from the judgment, that these 2 went to the house at 3 o'clock in the morning. Now, they did not give any explanation to that. That perhaps has gone. Otherwise, there is no reason for referring to Calcutta. So the court says there is no perceived reason.
There is a connection.
Yes.
There is a connection to refer it to Calcutta.
Yes.
I'll tell you. You see the quorum, you will find out.
106 will come in.
You see the quorum, you will find out. Quorum.
Okay. Yeah. But I saw that these are the things I saw. The judgment of 2003 and Calcutta was 1961. So Calcutta one could be a father, but not the same person. That happened to me. Anyway, whatever. So, but the only thing they did not explain what they were doing early morning at 3 a.m. at that point, that place. And that portion, I will please, your paragraph 9, I have an next, compilation 5. Ballot will come to paragraph 9. Why that was.
I was just explaining to my brother, why Calcutta? Why Calcutta?
Yes, yes. I thought it first, I had begun. Then I said, no, a difference will be too much. Yes. Your Lordship can come to page 43 of compilation 5. I have enclosed this. Sarwan Singh's case. There are 4 lines I will read from paragraph 9 at page 43 of compilation 5. Incidentally, in the early 90s, terrorist activities were on peak in the border district of Punjab, and it has practically been axiomatic truth in the area in question that no one would in fact come out of the residential house after dusk unless for force at 3 o'clock in the morning. There exists no other evidence, nor even there being a suggestion of the existence of any other factors for such perforce coming outing at 3 a.m. It is the rule of essential justice that whenever opponent has declined to avail himself of the opportunity to put his cross-examination, it must follow that the evidence tendered on the issue ought to be accepted.
So in fact, this is what is intriguing us. You see, when court expects the defense to be laid in the cross-examination, then our view at that point of time when we pose this query on servicing was, you see, what happens to the right of an accused against incriminating himself? If defense is laid, that means you are opening up your own defense when there is a right to silence.
Absolutely. One thing I may say, I can interrupt. If it's not clear, if they have admitted that at 3 o'clock they were there, then they must explain why they were there. 106 of the evidence it is this. It must be in your special knowledge why you were there at 3 o'clock. That too in a situation where nobody comes out there to comes out of the house. What you were doing there. This could be one, not the sole evidence. Here the evidence was an eyewitness who was injured. That has changed. And against that you say, I mean, the defense says that there was enmity. But they say that injured person, it is not, I mean, normal on his part to implicate a person who is innocent than a person who has really fired on him. So there is no way to disbelieve Mukhtiar Singh, who was there, and his brother was shot dead in his presence, and he also was injured. That was the turning point. This, your lordship said, is referring that they could not explain. It's not also clear whether they have admitted that 3 o'clock they were there.
Those things are not there.
Not there. So therefore, my submission would be that this case is of no use in the present case. Because there is no such facts. Then, my lord, I'll come just one more this thing, and then I will come down to the argument that has been placed by my learned friend, my lord, Mr. Chaudhary. Now, this is in respect of PW 23 and 24. Sorry, accused number 24, Raja Bidhu Singh. This was argued on 22/2/2024.
Yes, just a minute.
Now, my lord, so far as accused number 24, Brother Bidhu Singh is concerned, my learned friend, my lord, he took your lordships through that portion of the statement of PW 23, the bank manager, where he says that the loan was paid quickly in 14 days. But he avoided how the loan was paid by deposit, term deposit, and your lordship yourself questioned him on it. Then he says, my lord, that there is an evidence of the charter accountant which says that after production, they used to take back the books of account. On this, the argument is that this used to be done because they wanted the UNL leader to verify. From where he is saying this? There's absolutely no evidence. I mean, you cannot read evidence the way you want. Whatever evidence has stated, it is there. If he has not stated it, you can't bring in. So my submission will be that absolutely no defense argument was there on Brajo in case of Brajo Vidhu Singh, accused number 24. Then, my lord, I'll come to my learned friend's argument, where my major time, perhaps I'll have to devote on Sonu versus State of Haryana. Sonu versus State of Haryana. So insofar as my learned friend, Mr. Dilip Das is concerned, this was his argument, as I have been told. And the only takeaway from his argument, if your lordship permit me, the only takeaway from his argument that I got was when he said that PW7 is a Roman Catholic. Lordship, remember, they have told me, and he will not speak lie. His statement should be believed, perhaps. I remember a story, my lord. Your lordship, permit me. My lord, there was a father. And one morning, people saw he running here and there and asking, what happened? People ask, what happened, father? He says, better. Anyway, I'll come to my learned friend's argument, my lord. He has really made good efforts. He should. The only thing he did not go through the judgment before placing it. In this case, my lord, the facts are Sonu versus State of Haryana. There are glaring facts. The father of the informant, he went missing. He lost the first information report. Police came into this thing. Then many things happened. The accused were arrested. On their statement, the body was exhumed. Section 27 recovery. The personal belonging of the deceased was recovered, including key, ring, everything was recovered. So there's a watertight case, except that CDR on which they were perhaps talking to each other, that certificate could not be placed. So in that context, my lord, it was the law is laid down when certificate will be necessary or at what stage the objection can be taken. That is what makes it very interesting. But insofar as this case is concerned, this case is of no use because there was objection at the time when the evidence was taken, and it is mentioned in paragraph 52 of the judgment. Just 2 lines, then I will go, my lord, to the other, so that my learned friend also will. 52. 974, my lord. - 51, my lord, I'm sorry. Page 973. Opening sentence only will demonstrate that there was an objection to the admissibility. Challenging the admissibility of the email and attachment. And in cross-examination also, the question is put to the witness, PW 53 and 74. Satish Chandra and Siva Prasad Mohanty. I'll not take your lordship, it is there.
This Satish is PW.
Uh, Satish Chand is 53. Your lordship is asking the person who issued the certificate.
No, you said objection was raised.
Yes, objection was raised in respect of when both were being
So
examined.
PW 53
53 and 74. 53 is Satish Chand.
and PW 54 is
74
74.
is Siva Prasad Mohanty. My lord, I have annexed their statement in compilation 3 at page 59 and 81 respectively. Compilation 3.
50.
Page 50, well, PW 53 is at page 59. And PW 74 is at page 81 of compilation 3.
We'll take a short break and come.
I come to very interesting part of the decision, my lord. The lordship will kindly come to page. I have annexed, my lord, in compilation 5 at page 47. The decision, Sonu versus State of Haryana, which was placed by my friend, Mr. Chaudhary. Relevant, my lords may come to page 64. Paragraph 37, last 3 lines, I'm at page 64. There is no doubt. The lordship has got it, I'll proceed. There is no doubt that judgment in this case, in Anwar case. My lord got it at 764, compilation 5.
64, yes. 64 page.
64, paragraph 37, last 3 lines, I'll start from here.
Yes.
There is no doubt that judgment in this court in Anwar case has to be retrospective in operation unless judicial tool of prospective overruling is applied. However, retrospective application of the judgment is not in the interest of administration of justice, as it would necessitate reopening of large number of criminal cases. Criminal cases are decided on the basis of electronic records adduced in evidence without certification, have to be revisited as and when objections are taken by the accused at that appellate stage. Attempts will be made to reopen cases which have become final. This itself goes against the explanation of Order 47, Rule 1, where review is possible. In criminal, there is no review. But even in the civil cases, if a case is already decided, it cannot be reopened on the basis that law has changed by subsequent decision of this tribunal. If your lordship will take the explanation of Order 47, Rule 1 for a second.
explanation. The fact that the decision on a question of law on which the judgment of the court is based has been reversed or modified by subsequent decision of a superior court in any other case shall not be a ground for review of such judgment. So where is the question of reviewing a criminal case which has already been? And pending cases has to be governed by Bashir Anwar versus PK Bashir. There's no escape from there. Now, in so far as well the prospective and retrospective is concerned, I'm saying this just my lord for because it is referred, so I'm saying. The lordships remember, first time in our country, this prospective overruling was adopted in Golaknath's case. And the author of the judgment is Justice Hidayatullah, the great jurist, Justice Hidayatullah. Because they were, in America, my lord, there were Blackistonian theory, which says that when a judgment is passed, everything, unless it is concluded, it will affect. As if the law never existed, if something is struck down. The exception is those cases which have already been decided. Then there was other theory of prospective invalidation. So, my lord, their lordships in Golaknath. Golaknath was overruled in Keshwanand Bharati, but not on this point. On this point, this is the authority. So it says it will be applied in our country. They applied it, but the rider was that it can only be by the Supreme Court, not even by the High Court. That is in paragraph 51, my lord, if your lordship would like to go. We have annexed, my lord, relevant portion at page 69. And this is academic, actually, it doesn't apply here. Paragraph 60 at page 70 of compilation 5. There are two doctrines familiar to American jurisprudence. One is described as Blackistonian theory and the other is prospective overruling, which may have some relevance in the present case. I need not go any further. Then, my lord, will come to page 74. Page 73. Decisions are there. Right. Below by Q, this is okay. Paragraph 76. Yes. Page 71, your lordship will see paragraph 76 in this only volume. 76. As this court for the first time has been called upon to apply doctrine evolved in a different country under different circumstances, would like to move warily in the beginning, we would lay down the following proposition. The doctrine of prospective overruling can be invoked only in the matter arising under our Constitution. It can be applied only by the highest court of the country, that is Supreme Court, as it has the constitutional jurisdiction to declare law binding on all courts in India. Superseding its earlier decision is left to its discretion to be molded in accordance with the justice of cause or the matter before it. So this is the first time, first case, my lord, where prospective. So this judgment of PB Naseem will apply with retrospective effect because it has not been made prospective in effect by the court which has decided. It is only that court. And in any view of the matter, the cases which have already been decided cannot be opened. So to say that large number of cases will have to be reopened, in my humble submission, is not correct. There is a direct decision of the short decision.
So there is another factor we pointed out on that day.
Yes.
There's dates of examination and the date of the judgment. So that applies prospectively without.
Even if it applies prospectively, I'm just saying, then also we are covered.
Yes.
That's what you not pointed out, that's why I'm not. then I need not, my lord, there is a decision that it cannot be reopened on that. I don't want to bother your lordship. Now, there is another, my lord, Golaknath, he has referred that I have stated. Then, my lord, they say, in paragraph 3 of the judgment of,
Only page 47.
39, my lord. I'll just show how it has been coded. Page number 66, column 5.
60.
6. Page number 66 of compilation 5. This is a quoted portion, my lord, from a judgment. And I'll only refer to 2 lines above Precipitum C at page 66, paragraph 39, quoted portion. Quoted portion. The European Court of Justice, though cautiously and infrequently, has restricted the effect of its ruling to the particular claimant in the case before it, and to those who had begun the proceeding before the date of its judgment. Those who had not sought to challenge the legality of the acts perhaps done years before could only rely on the ruling prospectively. Such a course avoided unscrambling transactions, perhaps long since over, and doing injustice to the defendant. But what I want to say is that they have quoted here a judgment, but it is totally out of context. In my humble submission, my lord, the American doctrine was enunciated by Dr. Willoughby. Willoughby was a constitutional, he used to write on constitutional book. So he said, my lord, in America, suppose your lordship strikes down a provision in a particular case, that will be applicable only to the parties who are present before your lordship. It will not apply to others. And that was, if your lordships remember, during agrarian reform, when ceiling was imposed and the big landholders, lands were taken and given to the peasant or the actual cultivator. At that point of time, in Behram Khurshid case, it was said that the decision will be only confined to particular cases, not in all cases. So that was, my lord, rejected because Supreme Court says if we lay down a law, it will be a law for the whole country under 141, Article 141. Therefore, even if we strike a provision in a particular case, it will be applicable to all. Unlike America, there is no Willoughby here. And similarly, my lord, I also started looking that 141 is there in Behram Khurshid case. I'll just play one line before your lordship. But then I said, what will happen to the High Court? Then I got a decision of Tamil Nadu, which says if High Court strikes down a central legislation, if your lordship strikes down an act which is in Assam, there is no question of its bringing it back without any, it cannot be applied. Similarly, if your lordship today strikes a provision of a central act, even that will be binding throughout the country, unless they go and file an appeal. And that is why in T. Rajkumar versus Tamil Nadu, my lord, the same thing. I'll just place this, then I'll go to Behram Khurshid for a second. This is by Tamil Nadu. This judgment is by Sanjay Kishan Kaul, my lord. This is Sanjay Kishan Kaul, your lordship. Compilation 5, page 74. Page 74. Paragraph 4, just 4 lines, 2 lines I'll read from here. Otherwise also consists of 4 lines only. Then, copy. Copy किया लिखिए. They're taking the hint. You did not give, so they are also not giving. The paragraph 4, my lord, the first 2 lines at page 75. It is tried to say that once a High Court has struck down a provision of a central act, it cannot be said that it would be selectively applied in other states. Thus, there is no question of applicability of provisions struck down by the High Court as of now, until and unless Supreme Court upsets the judgment or stays the operation of the judgment. And this is very important, my lord. 141, it's a similar thing like 141. If your lordship strikes down the central act today, it will apply to whole of the country unless they go to Supreme Court and get some. So in India, my lord, in our country, there will be no question of application of doctrine of willow by. And I need not take your lordships to Behrampur seat to have done that. Is not also very relevant. Now I come to, my lord, again another part which will not be relevant to this case because there is an objection. But I'm really surprised, my lord. If your lordship will take Sonu once. My lord, relying on some Privy Council judgment. See? Here, my lord, they have called out. They've said that there can be 2 types of document. One, where the document itself is inadmissible. The other, the document is otherwise admissible, but because the procedure has not been followed, therefore it is inadmissible. He said in such cases, if the defendant or the accused has not raised, cross-examined or raised objection at the time of admission of the document, then subsequently you cannot. This is what the case is. And they have relied on one judgment of the Privy Council, Gopal Das, and the other is Venkat Chala. So these 2 types of document, your lordship quickly can have a look at what I have said at page 60 of compilation of Sonu's judgment. Relevant, I'm referring to 60. 60. Just few lines I'll read, my lord. They have quoted, my lord, R.V.E. Venkat Chala, Gounder. You have a next one. We have annexed that this case also. Your lordship will get the same thing here. I'm reading from here. Just few lines. Paragraph 30. In R.V. Venkat Chala, this court held as follows. 20 is quoted. Ordinarily, an objection to the admissibility of the evidence should be taken when it is tendered and not subsequently. The objection as to admissibility of document in evidence may be classified into two classes. One, objection that the document which is sought to be proved itself is inadmissible in evidence. Then they say it can be raised at any time, objection. Then second, where the objection does not dispute the admissibility of the document in evidence, but is directed towards mode of proof, alleging the same to be irregular or insufficient. So these two this is the classification made in this case regarding a document. My lord, first of all, since we have raised objection, it should not apply.
I'll tell you why. In this Gondar case, we have dealt with it.
Yes.
You see, you have give CPC. Sir,
We have.
we have. You see, proviso to Order 18, Rule 4. That is the reason.
No, I'm not disputing the reason. I'm not.
No, the reason the reason why this ratio was laid down is there. Order 18, Rule 4, proviso.
The 18 rule.
4, proviso.
Provided where documents are filed and parties rely upon document of proof of admissibility, which are filed along with the affidavit shall be subject to the order of the court. That this is a civil matter that, my lord, the present has been applied. I have no, my lord, quarrel with the proposition.
But provided where documents are filed and parties rely on the document, the proof and admissibility of such documents which are filed along with the affidavit shall be subject to further of the courts. So therefore, not only the trial, but what you call appeal and revision is covered. That's the reason, because this amendment came and was validated in 2002. So thereafter, this Venkatacharya order is 2003. So this is the background.
I'm on that the classification of document is all right. If the defendant or accused admits a document and only object to the admissibility on technical ground, and he has not raised objection, then it is said there that you cannot raise it in appeal. There's a point taken. Here what I'm saying is, this will not apply because we have taken objection. I'm repeating it time and again. Whether the output of a computer is a document. That's one question that I'm asking. My submission will be no, it's not a document. Evidence Act deems it to be a document. It's a deemed document on fulfillment of certain conditions. Your Lordship will kindly see 65A, section 65A of the Evidence Act. At page 52 also, Your Lordship will get of my compilation. Updated, right?
Section.
Section 65B.
Yesterday I was trying to read this and the new Evidence Act together to find out what is the difference, if any.
Somebody challenged the virus, Your Lordship herself want to know. Virus of these three laws.
Has been challenged.
That dismissed. That it has not even come into effect. You are it was dismissed by the Chief Justice Court. Yesterday.
But this will not be a bar. It can come up again after it is notified.
Yes, sir, it will not come. I have also not gone through. But it will be very difficult to pronounce. I'm from Hindi belt. Very difficult to pronounce. Never not used to. And Lordship, can you see 65B?
admissibility of electronic records.
Because you see, it depends on the adaptations. At one point of time, because of certain reasons, you see, now I can pronounce Komited Gozuzas Benoy Bejopas Nosti, that is KGB, full form of KGB. So once that can be pronounced,
The
others
Indians
can.
in Russia, they speak Russians. But then Indians in India, because of the diversity. I left my place, my lord, 48, more than 48 years back. I'm not used to it. It's very difficult to pronounce. I'm just expressing, maybe we have to get used to it. But hopefully, I won't be there. Well, let me play this, 4 lines.
No, because you see, after trial court, then matter will come to High Court, then he will be here, it will take about 20, 30 years.
Yes.
30 years down the line, he's proposing to retire.
Save of what? Achar Sanghita. I want to complete my academic knowledge, just 65 years or 65 years or two. Notwithstanding anything contained in this act, any information contained in an electronic record which is printed, this is email, on paper, stored or recorded or copied in an optical or magnetic media produced by a computer, hereinafter referred as computer, shall be deemed to be also a document, if the condition mentioned in these sections are satisfied. So it's not a document, it's a deemed document, and it will become document only when the conditions which are mentioned are fulfilled. Because deeming provision will come only if the conditions are fulfilled, otherwise it will not. Even Arjun Pandit say that, but after having said again, he says it's a document where no objection is raised. So not given the question. That is Justice Rohinton Narina's judgment. Oh, no. Lordship, kindly come to compilation 5, page 80, 80. I'm referring to a decision. Shalendra Shroop versus Deputy Director and Enforcement Directorate. At page 80. Relevant paragraph 45 is at page 81.
Yes.
Paragraph 45 at page 81, I'm placing. Section 68 of FERA 1973 deals with offenses by the company. Section 68 provides that, quote, every person who at the time of contravention was committed, at the time the contravention was committed, was in charge of or was responsible to the company for conduct of business of the company as well as the company shall be deemed to be guilty of contravention. Section 68(1) creates a legal fiction that it shall be deemed to be guilty. The legal fiction triggers
on fulfillment of conditions contained in this section, only this much. It will not even trigger, it will not even come into effect if the conditions are not fulfilled. And in the present case, what is the condition? Unless a certificate is issued, or the provision of this act is follows. The condition, the Lordship will see 65G. Shall be shall be deemed also to be a document if condition mentioned in this section. So entire thing has to be followed. 65B2, 3, 4. Will have to only then it will become a document, otherwise it will be a deemed document. So there is no parallel. I mean, even Arjun Pandit, the same thing is mentioned. Arjun Pandit was also referred by me and by them also. Compilation 2. Why don't you get that page?
Sure.
Page 113. Compilation.
Some property. That's fine.
113. Paragraph 32. Compilation.
Judgment.
Compilation, Arjun Pandit,
Oh, okay, compilation 2.
compilation 2, page 113. The relevant is page 113, capital A, paragraph 32. Coming back to section 65B of the Evidence Act, subsection 1 needs to be analyzed. This subsection begins with a non-obstante clause and then goes on to mention information contained in any electronic record produced by a computer, which is by a deeming fiction, then made a document. This deeming fiction only takes effect if further conditions mentioned in the sections are satisfied in relation to both information and computer in questions. And if the conditions are met, the document shall then be admissible in any proceeding. So no question of applicability of Privy Council and that Venkat Chala case, in my humble submission. Now, my lord, in one word, if I can say, Sonu Pandit is not applicable in this. Sonu, sorry. What? Sonu. Only Sonu. Only Sonu. Then the last point raised by, this was by Mr. Das. The last point that he raised is, we have not challenged Exhibit 185, that translation certificate. Certificate which says that the translation is correct by some unknown assistant professor in Bangalore. But I'll only say that PW 79 in cross-examination only we have challenged. In cross-examination, we have said, challenge this 185 and said this is fabricated document. Your Lordship will kindly come to page 84 of compilation 3, where we have annexed PW 79. 79, we have annexed. The relevant cross-examination your Lordship will get at page 86, compilation 3. Just cross-examination, few lines, if your Lordship. It is true that no mention was made in Exhibit 185 to 185-13 about the person who translated the email from Meithei to English. I do not know who translated the said contents of the email. It is also true that Exhibit 185, nothing was mentioned about person who issued the certificate. There is also no signature of any other particulars of certifying person. I deny the suggestion that contents of Exhibit 185 1 to 185-3 are fabricated and manipulated documents. I also deny the suggestion that Exhibit 185 is also a fabricated document. Then suggestions. It's not that it was not challenged. And can a document be admitted in evidence, my lord, which doesn't contain anyone's signature, a certificate? There's a question that I ask myself. And it has been reflected in the judgment that we have objected to this. And I have referred it earlier also, where trial court says that all our Manipuri, if there was something wrong in the translation, then they could have pointed out. The question is whether the learned judge himself knew Manipuri, because at the end of the day, your Lordship has to appreciate by going through the document, not us.
I answered a similar question when I was a kid. I said that I can read French. Subject, it is written in English.
I've taken already, your Lordship. We have challenged this. It's not correct to make a submission that Exhibit 185 was not challenged, therefore it is admissible, therefore the translation is authenticated, all those things. So, in my humble submission, my lord, I'll conclude by saying that in so far as accused number 6 is concerned, there are evidence which are there in email, Exhibit 115 series, which are not admissible as per my submission. Then, my lord, even if your Lordship holds somehow for some reason that it is admissible, then also I have taken your Lordship through the email
what it says. Accused 14 Langani and accused 6 jumped bail. Did you prove that whether we jumped bail? If we jumped bail, it must be recorded. Which case we have jumped bail? So it's like A writing to B, and the cost of repetition, A writing to B, that C has misappropriated the amount, and then it is placed in the evidence, because this is, email is nothing but letter. So this kind of evidence is there on which they are, my lord, the accused have been convicted under such a serious provision of law. And the law itself, my lord, the UAP. Then these emails will, once your lordship holds that emails are not admissible for want of certificate, the whole thing goes. Then 3 witnesses are left, 7, 9, 17, and 39, which has been discussed by the trial court. I have placed, my lord, they do not say, they cannot be read for the proposition that I am member of UNLF, or that I have invested on behalf of UNLF. There is no evidence to that. Now, so far as accused number
PW 7, 9 and
PW 9, 17,
9, 17.
and my lord, if your lordship remember, that day I said about keeping dogs. It doesn't concern me. But while going through the papers, I got a judgment of Punjab and Haryana. I'm not trying to help anybody, but if your lordship so please, your lordship may read this. I did not go further, I did, because it doesn't concern me. But this surprised me. Evidence of a peeping Tom, somebody eavesdrop and hear that cannot be an evidence. Now, your lordship may keep if it is of some use that. Then may not. So, sorry. Then may not, so far as accused number 24 is concerned, Brother Bidhu Singh. There is absolutely no evidence. The allegation is on AEDIS, not on Brother Bidhu. They said he is managing the fund. There is no evidence. And then again, the email has been relied upon. And this was exhibited by PW 44. And he doesn't hide anything. This is not secondary evidence of secondary evidence, because it was downloaded, printed in NIA, and then it was sent on, recorded on a sterile disk and sent to Chandigarh, FSA. And from there he takes out. It even cannot be called a secondary evidence. And it doesn't even take my name anywhere. It's about AEDIS, of which I was an employee. And then, my lord, in so far as the so far as PW 23, 24, and 43 are concerned, they don't say anything against me as such. So there is no evidence in respect of 824. Insofar as, my lord, 8, 11, and 15 are concerned, the only evidence is email. And if your lordship holds that these emails are not admissible, nothing will remain on record against them. And even otherwise, I have taken your lordship through the emails. Even if your lordship holds that the emails are admissible, the contents have not been proved. Nobody has proved. Somebody is writing to someone, saying something, and that be an evidence. So my humble submission would be, my lord, that it's a case of no evidence.
The written submissions have been submitted, and then certain chart your lordship says that he's making, I'll see it this evening. Only thing, my lord, I'll take your lordship's leave tomorrow afternoon.
But when you instruct Mr. Das, this, let's see. It was for him to instruct Mr. Das. Huh. You see, Mr. Das's argument was, which is controverted by Mr. Mishra, is about the production of accounts of ages before a chartered accountant. Now, please refer to section 80 and 81 of Assam Cooperative Societies Act. 80 says that accounts is to be maintained in the head office. 81 refers to auditor. And in Assam Cooperative Societies Act, auditor is appointed by the registrar. It's a statutory audit. Therefore, if a chartered accountant does not come and say that he is a statutory auditor, leaving of the books of accounts to him will not incite a adverse inference. Correct. So these are the two provisions, 80 and 81. We are just referring it to you when you instruct Mr. Das. Although this provision is not referred here by Mr. Mishra, but this is a fact which we are aware.
I will refer you to the senior counsel lordship.
Mm. But this is a case where we'll have to go by a house vote and take a vote on the issue whether you can be granted leave or not. Yesterday you had completed 145 or 17.
Completed, Lordship.
Yes, 263 and one is 145.
Yes, Lordship. There is another one, Lordship, 299 of 60, which I propose to do now. That is L. Dr. Singh relates to, he is accused number 17.
L. Jyotishwar Singh.
Dr. Singh. He is accused number 17.
He is accused number
He is accused 17.
17.
And he has been convicted under section 18 and 20 of the UAP Act. Under section 18, he has been sentenced to 8 years. And under section 20, he has been sentenced to 7 years.
121 is not there.
121, 121, he has been sentenced to 10 years.
121A.
121A, He has been sentenced to 10 years. And fine of is 10,000. Like the other two accused, uh, his conviction is primarily based on the downloaded emails. And the emails have been proved by PW 53 in all the cases. That is Satish Chand. PW 62 to get us. Lordship, I will not take your lordship to PW 53. Lordship has seen all those emails downloaded, executed by PW 53. I take your lordship to PW 62.
PW
PW 62. Your lordship.
62.
62. Your lordship will find at part 1, volume 2, page 346.
Part 1 volume
Volume 2,
2.
page 346. From Devinder Singh. He had taken over the investigation of the case on 24/9/2010. Lordship will find at page 346 itself, second paragraph. And 347, third paragraph, Lordship will see. He is the person who had sent the photographs of this particular accused amongst others to the CFSL. White exhibit 133. One, three, three. What Tetris? Lordship will find that letter at page 630. At part 2, volume 3.
Page number
630 in part two, volume three,
638,
633, 30.
630. Okay.
630. And the comparison of these photographs by now by PW 44. PW 44 evidence worship will find at page 276.
$300.
PW 44 at 276 of part one, volume two.
276, part 1, volume 2.
Part one, volume two. In fact, I had taken your lordship to this particular witness. Reference to the other case. And here also I would refer to page 280. Lordship will find at serial number 1. This is further re-examination.
So just a moment, this PW 62 you are referring,
He had sent the photographs to the CFSL.
oh, he had sent the photographs.
Yes, to the CFSL by exhibit 133. That is at page 630 of part 2, volume 3. In fact, all photographs on these three cases that I have been sent by 130. If I may take your lordship back to evidence of PW 44 at page 280. Sorry. Volume. Lordship will read this examination. Lordship will also note that in the cross examination, this witness has not been shaken, Lordship will read this evidence along with exhibit 204. Which your lordship will find at part 2, volume 5.
Just a moment, dear. When you're showing us, this PW 62, PW 62 says that he was,
He was IO.
no, I was given the charge of assisting IO. How far that can be permissible, we don't know. He's not the IO, he is assisting IO.
There was one main IO, that is Shyam
But
Prakash.
we don't know because under the NIA Act,
Yes,
it
lordship.
doesn't say about anything. How many IOs can be there, it doesn't say so. CRPC also doesn't say so. Now, assisting IO, we don't know that.
Lordship, I'll find out in one particular case, lordship, this assisting IOs have been held to be the no fault. I'll look at that case, lordship.
Now, this argument came up in a different context altogether. You see, position of Additional Advocate General. That was,
Not constitution.
no, that was,
Advocate General is constitution. This is not-
So that's why it is in that context I've just digressed.
Yeah, that's constitutional.
No, because IO, no, because you see what is happening is that IO is normally the last person to be examined and all the contradictions are
Yes.
coming through him. Now, if assistant to IO comes
Lordship.
and he deposes before the evidence of all the witnesses are completed, then question of contradiction from this witness may not be there because evidence is not yet over.
Okay, your lordship.
You see, IO comes at the last.
Yes.
That is a normal thumb rule because of the fact that contradictions, if any, can be brought to the fore on his examination or cross-examination. Cross-examination only. So if an assistant to IO comes and deposes prior to him and leaves evidence,
Lordship.
before the evidence of other witnesses are over, incriminating evidence is of 53. So question of cross-examining him at for contradictions will not come.
So far as
Therefore, you will have to also show that prejudice was not suffered merely because this procedure was adopted. Because there cannot be two power channels. In a case when it is investigated by an IO, charge sheet is led by an IO, then somebody to say that, well, I have done the investigation, he can't, he's just assistant.
he, it's state's lordship took over part investigation.
84 is the main IO.
PW 84.
I understand, but what is this charge of assisting IO? He can't do it. He's merely an assistant. You see, I have an assistant with me in my chamber. And I give him some work. Now, just because he did some research, he can't say that, well, the judgment were dictated by me. Or part of these paragraphs in this judgment authored by the Honorable Judge, paragraphs 2, 4, 8, 20 are authored by me. He can't come and say that.
This case is not confined to state of Assam. So,
So maybe you see there are so many aspects. We are not saying what you are doing is wrong. What we are trying to ask you from you is that, you see, somebody must take responsibility as an IO. So one man comes and says and deposes that I was the IO. Second,
He doesn't say, I died. He only said that I think part of the investment, this part of the investment, which was allowed. That is what it is. That's what I-
79.
Page 346.
3,
346.
just on 346.
Yes,
Yes.
the first paragraph. In 2010, I was posted as DHP NIA. The incident case was registered with the NIA on 17/9/2010, and I was given the charge of assisting IO as part of investigation under instruction of Chief Investigation Officer, Sri Swayam Prakash Pandey.
Well, if you say so, come to page 57, volume 1, part 1.
Volume 1.
Page 57, volume 1, part 1. Name of the IO, column 8 is Shyam Prakash Pani. No. You see, somebody says that I have done investigation. Part investigation was done by me. So he becomes an IO. But his name is not reflected as an IO in your charge sheet.
He is not taken, not a charge of.
No, but he says, you see, there's a specific date. He has said that I have taken a part of investigation on a particular date. Look at his evidence. That's why you see, I don't know, it is your case. You are showing us that there are two IOs. We are just asking you how.
And others, they assist him. That's. There is a team, madam. There was taken up, there is a team.
No, but you see, let us say a constitution bench in the Supreme Court of India. 5 judges, 7 judges, 13 judges, they sit. They all deliver their different judgments. Let us say in a case, for all 5 judges give a different judgment. All author their own judgment. So how does that is reflected in the judgment? It says by so and so. Then second part by so and so. So all these 5 judgments are narrated. This is how we know of. So if in a charge sheet somebody says that I did the investigation, so the issue is question of prejudice. You see, a prudent lawyer in the criminal side will keep everything, what are the contradictions to be put to the IO. But if somebody comes in between and says that I have done one part of the investigation, and his name is not in the charge sheet as an IO of that part. So if it is there in that part, then we understand that the question of prejudice will out to the accused will never be there. We don't know what's this.
There is a contradiction. Whether you're also accepted, there is a contradiction. There is a contradiction. So he allows some work to do a part of the president there in because he is busy here. Preparing the charge sheet or something like that. He collect the investigation and then he summarize and then put up on the charge sheet. That is what actually I thought they do. Otherwise, it becomes very difficult for the main IO to.
No, I'm not saying that you have to, only he has to do the investigation. We are not saying that for a moment. But if somebody has done a part of investigation, whether or not he becomes an IO.
Step into the supervisor.
Okay.
Perhaps this word assisting should have been assisted.
I don't know.
And
We are not imputing any motives. We are just putting that query. Once you make us read, we read.
some, sometimes English can be very difficult also.
That's okay.
Anyway,
My thing is that when I read, I read.
that is how we learn Lordship. Because whatever has fallen from your Lordship, it has got some meaning. I am reading PW 62 only for the purpose, Lordship, that this particular PW has sent the photographs to the CFSL for examination. And CFSL PW 44 is the person who had compared these photographs forensically and Lordship will find at page 280. I'll be reading from the third paragraph. The photograph of Q1 to Q6 stated to be Captain so-and-so, Jyotish sir, Major so-and-so. His names are given. After the comparison of the question photograph and specimen photographs using facial features and facial indices and superimposition technique, I have prepared my report that photograph Q1 found to be matching with photograph S1, that is. Worship this, there's a spelling mistake, it has to be. Jyotish sir, Jyotish sir. Here it is, given by is correct. His Lordship may read with exhibit 204 in part 2, volume 5. This is the report. More particularly, Lordship will see page 1120, column 9, Roman numeral. This is his report. Photograph is at 1101. The photograph.
Only this way.
on it.
Mr. Chaudhary, once you are showing us this, there are a lot of queries which are coming to our mind.
Lordship,
We'll show you. This witness, Devinder Singh,
62.
yes, he seized certain articles via exhibit 130. Correct. Now this 130 is at page 625. Before that, we come to 621 or 620 rather. 620 is exhibit 129. This is photo identification memo.
Lordship,
At around so and so, signature of this memo, one independent witness, several photographs of accused were shown to so and so, out of which he identified photograph of S. Rakesh as a person who is to come to his office for contracts for receiving and giving money to so and so. He has signed the back of the photograph.
Lordship,
Now, this itself is an evidence. 129 exhibit. He doesn't say that he's a member of the terrorist organization. So he came to the office, transacted with money for the purpose of contracts. That is what he says. Now, next page is 621. This is production cum receipt memo. Now here this IO, what he does is he seizes certain articles. This is seized by Trilokya Bora. He's SI of police. He is seizing it from so and so people. Name is in the third column. So fourth column. These are the particulars. Come to the next page, 622. Now he is seizing 50,000 in first, second is 6,500, then 15,590, 2,190, 6,000, so and so, so and so. So these are the seizure being done.
Lordship,
And he's being handed over this documents by page 621, exhibit 130, handing over of seized MR with articles and cash. Now here you see, he says, along with following MR with articles, total amount of rupees 6,79,000.
Lordship,
Now, then these are given to, for, along with others, his money of 17 lakh rupees is given to the IO 627 to the treasury, 17 lakh rupees. Now, in this previous document of 621, this no imputation of what this money is about. So this 2,170 rupees from one person in the previous page, we have shown it to you.
622.
So a terrorist goes to someone and extorts 6,500, 2,190, 6,600, 1,800. Really hard to believe. 30,000 rupees.
Lordship, this Lordship has obviously, they are not given money like that. They are given money.
No, that's okay. You see, no, you see, this money is, you are saying it's a terrorist activity. But there must be some proof. You see, when we are reading this evidence of PW 62, we're not finding that investigation is leading to a circumstance where this is, this money has any criminal links.
I was not on the money part, Lordship.
Okay,
I'm not on the money part.
okay.
As I have submitted.
You are basically on photographs.
The photographs, Lordship. And there is no explanation to that. There is no explanation to that. This particular witness I am only referring to for the purpose of the third
You have
paragraph.
seen the recent videos of a political person who is speaking to his AI image. No, you should see that. One of the best orators, he's competing and discussing with a AI. It's worth seeing.
That way one tends to understand better.
Hmm?
One tends to understand better when it is coming from the front. I say something and the AI would be better than me, so I prepare myself better.
We don't know, you see, but the thing is that when you can't distinguish, the problem is that this photograph, original photographs, we have raised a query on the last occasion. This photographs with which it was compared, those photographs were not exhibited. Now, if I am asking a third party to identify X with a photograph, he does the analysis and says that this photograph is of X. And you put that question to that accused X in his 313 saying that so and so has compared it and it is your photograph.
Perhaps.
Now, what is the possible reply which can come?
Perhaps, Lordship, if.
I'm just thinking, what could be a possible reply by the accused? Somebody has done something I don't know.
Perhaps this paragraph at page 281.
281.
The photographs which were sent, the question photographs compared, which were sent, have been returned back, sealed, and that was opened in the court. Come to page 280.
63 page?
281 in
281.
volume, part 1, volume 2. if I may read, Lordship. Lordship has got 281. After examination of the above photographs and the report was submitted to the investigation agency, NIA, exhibit 2041, 2042 are my signatures. In photograph Q1 to Q6, I put my initial on every photograph, which are marked as exhibit 2043 to 2048. Today I have seen the seal packet. Again, seal packet with the seal which I am authorized to use, which is marked as MO83 containing the photograph. The same is opened today with the permission of the court. The envelope contains 6 photographs which were marked as S1 to S6. After examination of the photographs which were exhibited as exhibit 205 series, I put my initial in each of the photographs which are marked as exhibit 2051 to 2056. Today, I have seen the seal packet with the seal which I am authorized to use, which is marked as MO 80 by 3 containing 1 DVD. So this DVD I will just skip for a moment.
But you see, it is marked as S1 to S6, but those were not exhibited.
Those were open, Lordship.
After examination of the photographs, which are exhibited as 2050,
Yes.
I put my initial in those photographs, so and so. So he's proving the compared photographs. Please read it again. The envelope contains 6 photographs marked as S1 to S6. After examination of the photographs which are exhibited at 2005 series, I put my initial in each photograph which are marked as so and so. These are compared photographs. Because no exhibit is marked as S1. Yes.
This question, very simple. Both are marked as, both are exhibited as 204 and 205.
এটা এটা থাকা Hmm. Uh, Just, for your- if I may, Lordship, the Lordship will just come to page 1, 2, 3. Yes, you will see there's an endorsement. An endorsement. Yes, so it must be somewhere in the, because these are the sample photographs.
Okay.
Now. This envelope was opened.
Just- You see, the advantage of a trial court experience comes in. You see, brother has rightly pointed out, what happens in a trial is that the accused, by an order of the magistrate, is required to give his signature or whatever document is sent for forensic examination. Those are taken by the orders of the magistrate or by the IO, and then those signatures are admitted by the accused persons. And then it is sent for forensic examination. So therefore, samples which are sent is not a disputed sample. Correct. Now, even same in the NDPS cases, the documents are, the question packets are sealed. Then from there, samples are taken. Everything is recorded, and then forensic examination. Because immediately when it is searched and seized, then it is sealed. From there, samples are taken and sent. So this is the normal procedure where nobody is questioning the signature or drugs which were procured for the purpose of examination. Here till now we have not introduced that. There's a presumption that this is a photograph taken of the accused person and then sent. You see this time when it is sent, we are not aware of the time when it was sent. We are not aware of that. Now, we are asking you this because of a particular reason. Now, these persons are in battle fatigues. So that means wherever they are in custody, were they permitted to wear that? Because they are in custody. So therefore, what is being done is that a photograph is taken in a combat fatigue.
I would just like to differ from your worship here. Photographs in combat uniform was downloaded.
No. Now you are saying that these photographs were compared. Okay, that photograph is not here. That is in the seal packet. 205. Okay. Okay.
So, worship, it's a common practice once arrested. Photograph is taken.
That evidence is.
That,
One set, one set of photograph.
that is, sample photograph will be here. In that,
You have to make it. One set.
so the sample photograph which is here, that would be compared with what has been downloaded. Because in any case, nobody will wear that battle fatigue here. So, and from what transpires, they were staying here just like simple families. Now, if you're both the sets of photographs were there in the court when this particular PW was examined, and lordship will see the cross. At 281. At 281. Nothing to rebut. The position of PW 44. One accused declined to cross-examine, and other accused had cross-examined him at 281 below. The methodology or the techniques applied by me in the comparison of the photographs are mentioned at paragraph 9 of my report, that is exhibit 204. The seal cover of MO 83 containing photographs were opened today, only today, with the permission of the court for the first time before this court. As I am CFSL expert, as such I am not aware if the material objects examined by me are incriminating or not. As the investigating agency had not asked for the examination for the same. So he was asked only for the comparison of the photographs, and which he says is this photograph is of this person, and there is nothing here, although they were except for Monit and the others cross-examined, they could not rebut it, lordship. Now, so far as the other emails are concerned, I would take your lordship to exhibit 1151. I had referred to it before. That would also be relevant here because it speaks of 11 cadres who were arrested from Guwahati. Perhaps Lordship need not open that. It is at page 422 of part 2, volume 2, which refers to arrest of 11 cadres from Guwahati. And he was one of the persons who have been arrested from Guwahati. Twenty-three to go to sir. No, no, no. 73 to go to sir. Now, if I may take your lordship to that 115 series, 11573, that your lordship will find at 441. Now, lordship will, I'll just draw your lordship's attention. Lordship will see who has sent it to whom. One side, they are very concerned in page 422. They are very concerned about the arrest of 4 cadres in Guwahati. And if your lordship will see 441, this is Telemba. Who is Telemba? Telemba is in 17. If your lordship will see, friend Telemba is advised by doctor to take rest. Who is Telemba? Telemba is A17, the present appellant here. He is good one. Captain Lorembam Telemba alias Jyotiswar. Now, organization who is so concerned about the arrest of its cadres from Guwahati, it would normally not have any lordship, feelings for any other person because one of their cadres was it may suffer from paralysis. They are concerned here. At 441 lordship. Lordship will note from whom to whom. These are the same emails which your lordship will find at page 422. I can understand my friend falling sick, recommending a doctor. But at the same time, if my friend is an anti-national, again I go to take care of him. Until and unless lordship they have a close relation between themselves, nobody would do that. Now, if I may take your lordship to the 313 examination, more particularly, report us, sir. Of this particular appellant, lordship will find at part 1, volume 4, lordship, part 1, volume 4, page, it starts at page 855. The
Page?
It starts at page 855
855.
and the relevant page could be 858. I'm taking your lordship to question number 13.
858.
858, lordship. Uh, Question would be question 13. PW 62, Devendra Singh has refused that he was Deputy SP NIA during the part investigation. Then A18 photograph by exhibit 132 and your health officers 17 photograph Viva so and so for comparative matching. What have you to say? Lordship here, naturally, Lordship, he would not have anything to say. The question of to be have been framed so far as comparison is. But the second part, and I am not aware of the allegation. Now, Lordship, either he did not understand the question, or this is a premeditated answer because there is no allegation.
No, in other case, on the other questions, he doesn't say that.
Lordship,
12, he says, I don't know.
Lordship,
11, he says, I am not aware. So,
no, I am not aware, Lordship, if your Lordship will see the question, I am not aware does not fit in of the allegation, because there is no allegation in this question. Uh, Now I take your Lordship to question 29. At page 864. Uh, uh, From around 10 lines from the bottom, Lordship, it starts with at E79.
Yes, yesterday also you referred this.
Yes, same thing, because here also, Lordship, his photograph was also sent. And Lordship, without reading it, Lordship, just come to the answer. That page. Because rest part is the same matter. He says, I have no knowledge. And in Lordship will remember in the cross also, there is nothing.
Because you see here, the question at page 865. Is the witness also stated that these emails were part of the disclosure followed by recovery of email of A18 and 19? What do you want to say?
Yes.
So that is the question frame. He says yes. I have no knowledge. You see, it's a long question which creates a disturbance.
That's the problem with long question. Which part he is answering? Is he answering? Because if I say, Lordship may be correct, so far as the last part is concerned. Lordship may be correct. I'll say maybe. I'll not say Lordship is correct. Lordship may be correct. But what about the other part?
Yeah, Brother is not here. Other one, what these questions are prepared. And 13, I think, 313, clause 5. These were given to the advocate. They've taken enough time.
Oh,
When it is, what it is, Bharat? Saying. It's not that, Bharat, like, Assam cases, Bharat. The question. The position. The short case. That is, of course, your will. It is not that it is prepared. That's what said that.
that Lordship, because definitely these answers are from the advocates. If they were supplied the questionnaire before. That is why Lordship short answers and now if I may take your Lordship to the, I'm sorry. Judgment to good. Lordship, the trial court has referred to this particular accused in paragraph numbers, if your Lordship, I'll just get the paragraph numbers, I have read it before. Paragraphs 35 36. Yes, Lordship.
Paragraph,
Paragraph 35, 36, 37, 43, 44, 45, 46, and 47. And the conviction and sentence will come, Lordship, from paragraph number 80,
please repeat it again, para 35,
35, 36, 37, 43, 44, 45, 46, and 47. And the learned judge discusses on the conviction from paragraph 80 onwards. Conviction and sentence from paragraph 80 to 103.
80
80.
to 103.
103. Shipra. So far as Lordship, this particular use is concerned, Lordship, I have already made. And this, it is based on the downloaded emails and his complicity is on that basis. So I will not go through the paragraphs once again. But not know whether the time will permit. I would like to address your Lordship on 2 points. Your Lordship will allow me now or after my senior completes.
You chose between you two because we'll be rising. We'll have this bench broken at 3:20. So there's a single bench.
3, 4 points.
And you can wind it up right to now. We can close it.
Lordship, I will just address your Lordship on 65B and section 20, which my senior has addressed. If we can do it tomorrow, Lordship. Because what sir has submitted, there is some contradiction, which I. I will not take much time.
That will be subject to what questions I ask, we ask.
That is the main aspect.
With permission of the court, Mr. D.K. Mishra, Learned Senior Counsel, for the appearance in the first order, you will find it. Appearing for appearance, so and so has given reply to the has given his reply submissions. Full stop. The Mr. D.K. Das, Senior Counsel, assisted by Mr. D. Bharadwaj. Learned Counsel is present. Submissions of Mr. R.K.D. Chaudhary, Learned DSGI, remains inconclusive. List tomorrow. Either.
Single bench, item 1.
Last when we stopped, we were referring to the issue as to whether the suit patta 243 fell in the share of Purni. And you were referring to that patta number 37 was in the name of Bhutkuri solely, and then patta number 243 was in the name of Purni. So you are saying that there was already a partition.
Not,
And then you are referring to the appellate court decision on that issue.
perhaps trial courts.
No, appellate court. You said that appellate court had the adoption was accepted. And the transfer had to be hit by section 52. This is what you are referring.
But it's very to make note, not my argument, but just to indicate the. If the plaintiff's case, the defendant's case, the findings of the trial court and the findings of the appellate court.
Yes.
We refer to this just to give the background.
Yes.
Just quickly refer to that. So, Lord, firstly, undisputedly, Forgodhar Mali was the original owner of the Schedule A land measuring 6 bighas and more, covered by Patna number 243. Now, Forgodhar died, leaving behind his wife Galpuri and 2 daughters were Bhutkuri and Puri. Now, my lord, Purni was married to Pitom. Pitom had a brother, I'm referring to the third one. That note. Purni was married to Pitom. Pitom had a brother called Poraram Das.
Poraram Das, yes.
Poraram Das had married the mother of one Haroram Das, and Haroram Das took shelter in the house of Purni Das. Subsequently, Pitom, Pora, and his second wife died,
and only these two remain. Haro Ram Das continued to stay with Purni.
No,
Das.
here I have written the submissions of, to the effect that the court did not decide whether Puraram Das was the adopted son of Purnima Das.
Oh, no, Poru was the adopted son of Purni. Poru. Haro, sorry. Haro.
And it's Puraram Das.
Puraram Das was the brother of Pitom, who was the husband of Purni Mulad. This is their case, also.
Their case is the Puraram Das is the father of the defendants. He was adopted by Purni Das.
Their cases, Mulad, they do not admit adoption, Mulad.
Khorgeswar Das is the maternal grandfather of plaintiff.
Yes.
His wife is
Galpuri.
Galpuri. Daughter is Purni Das,
And
no issue. And then daughter is Bhutkuri, who is the plaintiff.
Yes, plaintiff's mother. Now, Purni was married to Pitom. They were childless. And Pitom's brother Poru had brought in Haro and his mother. So basically, the Haro used to stay with Purni. But they say there was no adoption, there was no blood relation. Now, my lord, their case was that Patta number 243 was divided. Patta number 243, there was a village committee decision as per which it was divided among the two sisters. And out of that, the land they claim fell in their possession. Now, Purni was initially arraigned as pro forma defendant, my lord, but she died during pendency and she did not file a written statement. But just prior to her death, she executed a gift in favor of the defendant. Now, that gift deed was also challenged, saying that Purni was probably not in sound mind, and therefore the gift is not valid, besides being hit by section 52 of the Transfer of Property. But our case was that the lands of Thorgodhor Mali were divided amongst the two sisters at the, during the lifetime of their mother Galpuri. Now, as per that division, Bhutkuri got her share in a separate patta, which is patta number 37, and the suit patta 243 was vested with Purni. Now, since Purni and was issued as honor, she adopted Haro, who happened to be the nephew of her husband. Now, thereafter, in 1976, Purni made an oral gift of the entire land in favor of the defendant, and subsequently she executed a gift deed in respect of a portion of the settled area. If I may quickly take your lordship to the findings of the trial court. Page 41, if the lordship may take up from the main.
Who were the witnesses to this adoption?
Adoption, my lord,
Any witness came and proved?
DW3 had said, my lord, and there are certain depositions made even by the PW that they were Haro Ram Das was always with Purni, and I'll read one portion of that evidence of PW3, my lord. Now, one or two broad issues, three broad issues perhaps would be important here, you know, whether 243 was divided among Bhutpuri and Purni, or whether 243 was exclusively vested with Purni and Bhutpuri took her share in 37. So that is the findings at page 41 of the trial court judgment. I mean, the last paragraph, if we consider the entire evidence. This is dealing with the issue whether 243 was exclusively Purni. If we consider the entire evidence on record, it will be found that according to the plaintiff, Khorgadhar Mali and after him Galpuri had only the Suklan, and the Suklan was divided in between two sisters, Purni and Bhutpuri in equal share, and the plaintiffs were possessing the shares of their mother Bhutpuri, and the defendants were possessing the share of Purni. But according to DW1, Khorgadhar Mali and after his death, Galpuri had more than 11 bighas of land, which was divided between two sisters, and Sut land fell in the share of Purni Das, and they were in possession thereof. Exhibit 1 and Exhibit 4 are the certified copies of the Jamabandis of the Sut land in the name of Purni Das. Exhibit 1 and Exhibit 4 clearly prove that the Sut land has been mutated in the name of Purni Das. Exhibit 1 and Exhibit 4 does not prove how Purni Das got the Sut land, but the certified copy of the Jamabandi of so village of 1957-64 proves that Galpuri had 11 bighas, 8 lechas of land in different dars. In Patta number 20 old and 37 new, remarks for therein clearly prove that by an order of the ASO dated 5/15/59, the lands of 278, 12 and 464 have been recorded in the name of Purni in Patta number 243. And by an order dated 31/62, the remaining lands were recorded in the name of the plaintiff as heirs of Galpuri. It also reveals that the name of some other persons have been mutated in Patta number 37 by way of purchase from the plaintiff. Therefore, the documentary evidence clearly proved that Galpuri had 11 bighas of land which she gave to her two daughters, Bhutpuri and Purni. Bhutpuri got the land of Patta number 37 measuring 4 bighas 9 lechas, and Purni got 6 bighas 4 bighas 19 lechas out of the said Patta number and was recorded in her name in a separate Patta number 243. From the evidence on record, it is crystal clear that the plaintiff suppressed the material facts regarding the total land of their predecessor and the division made by the predecessor thereof in between the two sisters. Moreover, PW1 in his cross-examination categorically stated that they have sold out some lands out of their share. Exhibit 1 as well as Exhibit 4 do not prove that the plaintiffs have sold any land out of this Patta land. So the plaintiffs would have got their share in Patta number 243, it's a typographical error, and they would have sold some land. That fact would have appeared in Exhibit 1 and Exhibit 4. On the other hand, certified copy of Patta number 37 clearly proves that the plaintiffs have sold some of the lands of Patta number 37. This clearly proves that the plaintiffs got their share in the land covered by Patta number 37 of village Mirzapur, and Purni got the Sut land as her share. The fact that the plaintiff did not get any share in the Sut land is fortified by the evidence of PW1. Evidence when PW1 stated in his cross-examination that he had no possession over the Sut land. If the plaintiff would have got any share in the Sut land, they would have been in possession therein. Therefore, the entire evidence on record clearly proves that the Sut land covered by Patta number 243 fell in the share of Purni Das, and she had rights and interest in possession thereof to the defendant. Evidence of PW 1, 2, and 3 that half of the Sut land fell in the share of Bhutpuri cannot be believed in as much as PW1 in his evidence suppressed the material fact regarding the total quantity of land left by the predecessor. And PW2 and 3 cannot be believed as they do not know what the total quantity of land possessed by Khorgod or Mali, and also they did not know how much of land in what class Purni and Bhutpuri got. In the case of the plaintiffs, that they got half of the share of the subland, therefore failed. Now, my lord, this is insofar as, so trial court came to the finding that 243 was exclusively Purni. Now, insofar as the gift deed is concerned, the lordship will skip over to page 45. My lord. Number 4. Start from page 44. PW1 in his evidence deposed that Soni Das did not make any gift of her land in favor of the defendant. PW2 and 3 had also deposed that to their knowledge, Purni did not make gift of the suit land to the defendant. PW1 on the other hand deposed that Purni during her lifetime endorsed in the chitta for mutation of their name in respect of the half of the land, and accordingly their names were mutated. They also deposed that the remaining lands were gifted to them by executing a registered gift deed. DW so-and-so deposed that he wrote exhibit for the deed of gift executed by Purnibala Das in favor of Bhatta Das and Probin Das. Exhibit 4 to 4, 1 to 4 are his endorsements under the thumb impression of Purni. Exhibit 4-5 to 4-8 are his signatures as the writer of the deed. He also deposed by exhibit 4, Purni Das gifted so-and-so in document number 13, 304, 470, 475, 243. DW3 is the attesting witness who also deposed that Purni executed exhibit 4 and 4A in his signature. DW3 also deposed the defendants accepted the gift and put their signatures in exhibit 4 and 4.1 and 4.11 are the signatures of Bhatta Das and Probin Das respectively. Although the plaintiff witnesses have deposed that Purni did not make any gift in favor of the defendant, but the evidence of DW 1, 2, and 3 clearly proves that Purni Das made the gift of the subland in favor of the defendant by a registered deed of gift, exhibit 4, and the defendant accepted the gift. Now, this is insofar as execution of the gift is concerned. Now, page 14, then thereafter, the validity is also decided. And the learned advocate for the plaintiff submitted that exhibit 4, the deed of gift was executed during pendency of the suit plan and is subject to the decision has submitted to the defendants of this court under section 52 of the Transfer of Property Act. In support of his contention, he cited the case law reported in so-and-so. In this case, it was held by the lawsuit if the property was acquired pending in life. The acquirer is bound by the decree ultimately obtained in the proceeding pending at the time of execution. It is a fact that if any property is transferred during the pendency of a suit, the acquirer is bound by the decree that may be passed in the proceeding. In the instant case, in the instant suit, Purni Das executed the deed of gift or during pendency of the suit. The plaintiff in the suit has not challenged the right title and interest of Purni Das in the suit land. On the other hand, the plaintiffs themselves have claimed the suit land as heirs of Purni Das. This clearly proves that plaintiff admitted the right title and interest of Purni Das in the suit land while she was alive. When Purni Das had right title and interest over the suit land during her lifetime, she had a right to make a gift of the suit land to the defendants by exhibit 4. Accordingly, the defendants have acquired the right title and interest over the suit land by virtue of exhibit 4. Thus, the evidence on record clearly proves that Purni Das during her lifetime on 15 to 94 gifted the suit land to the answering defendants by exhibiting registered deed number so-and-so. Issue number 4 is accordingly decided in the affirmative. So these are the broad findings of the trial court. It holds that 237 could be Bhutpuri, 243 is exclusively Purni. Purni executed the gift deed, though it could have been a pendant-like transfer. But since now, after the death of Purni, the plaintiffs themselves claimed the land as heirs of Purni. So therefore, Purni's right is established, and if her right is established, then she had the capacity to make that disposition as per the gift. Now, of course, adoption was not dealt with in the trial court judgment. Now, the first appellate court, my lord, page 57, if your lordship. that judgment of Devi Prasad was put. Page 54, the second paragraph. In the above decision, the apex court has been observed that human affairs have to be judged on the basis of probability. Thus, the relationship of defendant number 1 and 2, Pitomdas and Punita, is to be adjudged as stated above in the light of the above decision. According to the evidence of the plaintiff, originally PW1 and Sukland or originally belonged to Forward Hort, and after his death, the same was mutated in the and after her death, the same was mutated in the name of Purni. Both of them had been possessing their respective land. They exhibited the certified copy of exhibit. Further stated that after the death of his grandfather, his grandmother, he is saying on the cross-examination, they has no possession over this. He has already sold some portion of the land of his mother. Further admitted there is no knowledge about the share of both of these. I thought Katuria and from crossing them. Sold most of the land of their mother. On the other hand, Pattoram Das is one of them because Galpuri had more than Puri got 4 bigger night of Galpuri for Pumi adopted his father. W2 Anwar Hussain and DW so that the defendants are grandsons. Plaintiffs are filed suit in the year 1990. Defendants are their grandson. Statement father was about 50 years ago. As stated in the written statement, Aroram was adopted during the lifetime of Tom and as proposed by DW. Which he could do during prior to the commencement. As in the present case, question adoption arises after option, such it is evidence of the land in question. Also not dispute, Aroram was reciting the evidence of the parties which is found that they also recognize dependence after the or the adoption. One is deemed to be a child of the adopter as such in view of section of the Section Act, property left by only upon the other hand, both the parties are in copies of Jawabal case or respectively, was that the land of defendant also by way of gift, but in view of section 1 transfer of property, transfer must be appears that the former defendant had executed. The defendant executed another deed of gift purportedly executed by the pro forma defendant. Him is hit by the provision of section transfer of property as the same. Instinct suit and was originally belonged to Fortunor and thereafter muted. Alpuri after muted only. Both the plaintiff and was decided between Alpuri and Purni committee. Agreed that come in the proceeding. No such proceeding before the partition. The other hand, the PW1 is cross-examination that out of the care of their mother, some land have been sold by him. It also implies that the land of Gurukul came from the alone, no one. That of holy and devolved upon the sons of the adopted son to write title and interest of the suit. Basically, now the appellate court has held that gift is not, but adoption, that but the collective evidence of abuse and together, the supposition was that Haro was being the adopted son, and if Haro is the adopted son, then a formal line of succession and the requirement of the degree was not necessary. Substantial
Repeat your last part again. If the adoption is correct.
adoption is proved. The appellate court held adoption is proved. So in view of adoption, I inherit under section 15. And therefore, the fact that the gift deed was found to be invalid was inconsequential. This is the sum and substance of the appellate court finding. Basically, my lord, while the trial court said that I acquired title on the basis of the gift, appellate court says I acquired title on the basis of upon the fact that I'm an adopted son and therefore entitled to inherit under section 15. One of the substantial questions of lots more questions were framed, that is whether the learned courts below wrongly applies the provision of section 15(1) of the Hindu Succession Act 1956 and instead of 15(2)(a) of section of the TED Act. Section 15, perhaps what they want to argue is if the adoption is not proved, Haro would be an heir of the husband of Purni. And since this property in question was inherited from Khorgho Das, as in the father of Purni, therefore 15(2) will apply. In which case it'll devolve upon the heirs of the father. (15)(1) says the property of a female Hindu dying intestate shall devolve according to the rules set out in section 16. A, firstly upon sons and daughters, including the children of any predeceased son or daughter and the husband. Secondly, upon heirs of the husband. Now, they're saying that as opposed to 15(1)(b), it is 15(2)(a) which will govern. 15(2), my lord, if I may read.
It will be on the heirs of the father.
Heirs of the father. So they are basically saying it will be governed by 15(2)(a), and upon Purni's death, it will devolve upon heirs of the father, thereby Bhutkuri's sons would inherit. Now, this again says 15(2)(a) again says in the absence of any son. Any property inherited by a female Hindu from her father or mother shall devolve in the absence of any son or daughter of the deceased, including children of any predeceased son or daughter, not upon the heirs referred to in subsection 1 in order specified therein, but upon heirs of the father. Now, this
Heirs of the husband.
heirs of the
B's, B's husband.
B's husband, I'm reading 15(2)(a).
A, okay. Father,
15(2)(a).
father.
Now they are probably saying that since it was inherited by Khargodhar Mali, it should go back to the heirs of the father. And if heirs of the father step in, my lord, Bhutkuri's sons would inherit. Now, this question, in my respectful understanding, is a little misconceived in the sense that 15(2)(a), even if 15(2)(a) operates, my lord, firstly, it is only in the absence of a son that it will go back to the heirs of the father. Now, absence of a son, the word son, as per the Hindu Adoption and Maintenance Act, section 12, would include an adopted son. So this question is, unless they set aside the findings of the appellate court regarding adoption, 15(2)(a) will not come to their resolution. Now, my lord, insofar as adoption is concerned, my lord, there were materials before the court. First of all, my lord, I'll refer to the LCR shortly, my lord. PW1 says, I can't say whether they are adopted son or not. Though his specific case was they are not a son, Horu was not a son of Purni. But he says, I cannot say whether there has been an adoption of Horu. PW2 again admits that Aro used to stay with Pitom and Purni. And in fact, Aro's marriage was also arranged by Pitom and Purni. That is PW2 stand.
Marriage was performed by
Purni. Aro's marriage was arranged by Purni and Pitom.
Pudi and Pritam at that time.
PW3 on Ramchandra Das, his evidence, though I've read, my lord, it's there in the record, my lord. Certain areas, not should will have that PW3 rest. I will not trouble because there's something which even I could not understand with certainty. PW3, if your lordship permits, and take out from the LCR. Now, PW3 also says Haro stayed with Purni throughout. So Number one, PWs admit that Haro was always staying with Purni and Pitom. And secondly, like I said, that the marriage was also arranged by Purni and Pitom. And PW3 says something additionally. Apart from these circumstances, something that we grew up to from your lordship, on the last day, the gift deed, which execution is proved, uh, also refers to the defendants as more needs nothing. So that is another evidence which lends support to the factum of adoption.
Yes.
Sort of the last portion of the cross-examination, the last page of that, because it's. Yes. It should be on the flip side.
Yes.
Last but 5 lines. বিবাদী সত্য আৰু প্ৰবীণৰ দেউতাক অৰূপ পূৰ্ণিমা ও প্ৰীতমে তুলি লৈছিল নে নাই মই নাজানো। Have you also complete?
This handwriting is not very. But please read it again. Pritama.
The sentence last but 5 lines in my certificate copy, বিবাদী সত্য ও প্ৰবীণৰ দেউতাক অৰূপ পূৰ্ণিমা ও প্ৰীতমে তুলি লৈছিল নে নাই মই নাজানো।
হ্যাঁ, তুলি লৈছিল নে নাই মই নাজানো।
Thereafter, আৰু তেওঁলোকে পালিতা হিচাপে ৰাখিছিল। নালিচা জমি খণ্ড পূৰ্ণিমাৰ ভাগৰ জমি হ'ব। So this witness admits that everything is true. Last sentence, my lord. পূৰ্ণিমাৰ কাম কাজ সত্য প্ৰবীণে কৰিছিল। Now, my lord, though কাম কাজ may mean chores, my lord. Exactly, like my friend admits, rituals were performed by Hatto and Kobi. So Kaj basically means funeral rituals. They were also performed by the defendant. Now, my lord, why I'm drawing your lordship's attention to all these aspects is because, like the appellate court had already held, that there cannot be any concrete evidence, so we must look into circumstances.
Whose কাম-কাজ?
Purnimar Kamkaj. Kaj, my lord, if it were chores, it would have.
কাম-কাজ, হ্যাঁ।
Would have probably read as Kamkaj Hatto or Probine Korisil. Now the fact that Kaj may also refer to funeral rites, and it says Korise. So therefore, the funeral rites were also performed probably. That is what can be gathered. First, subject to what your lordship said. Now, followed what transpired.
কাম কাজ হয়তো আৰু প্ৰবীণে কৰিছে।
Now, what transpires from the evidence? Number one, Haru was always with Purni. He was sort of a palita, as in he was kept with them. Thirdly, his marriage was also arranged by Purni and Pitom. The last rites of Purni were also done by the defendants. The defendants were always recognized as grandsons. So all of this evidence put together leads to the inference that Haro was the adopted son and resultantly the defendants were the grandsons of Purni. Now, adoptions of such an antiquity are difficult to be proven. There's one judgment which is already cited by the appellate court, and I'll rely on one more. But before that, my lord, the basic argument of my learned senior is that the other judgment of Devi Prasad would not apply because there were other circumstances, other corroborating evidence, and there is none in our case, and therefore adoption was not proved. My lord, before I go to that issue of adoption, my lord, essentially what the appellant seeks to argue is adoption is a factual question of fact. There are rightly or wrongly some evidence on record, my lord. It is not a case where adoption was held to be proven without there being any evidence. The argument is regarding sufficiency of that evidence, whether the evidence on record was sufficient to hold that Haro was the adopted son of Purnima. But to that, my first answer would be that ultimately we are here under section 100. So to make out a case of perversity, they'll have to make out a case of no evidence rather than less evidence. Now, even if it is a case of insufficiency of evidence, my lord, this court perhaps would not interfere under section 100. Had it been a case of a complete perversity that there was no evidence on admissible evidence on record, the question would have been otherwise. But since there is at least some evidence on record, sufficiency or otherwise will not be visited by this honorable court. Whole judgment, my lord, refer to paragraph 12 of that judgment. Paragraph 12. It appears that the decision of this court in Patta Hirama Swami was in fact cited before the learned single judge, but he was inclined to take the view that some aspects of the provisions contained in section 100 of the code had not been duly considered by this court. And so he thought that it was open to him to interfere with the conclusions of the courts below in the present appeal. According to the learned judge, it is open to the second appellate court to interfere with the conclusions of fact recorded by the district judge, not only whether said conclusions are based on no evidence, but also whether said conclusions are based on evidence which the High Court considers insufficient to support it. In other words, the learned judge thinks that adequacy or sufficiency of evidence to sustain a conclusion of fact is a matter of law which can be effectively raised in a second appeal. In our opinion, this is clearly a misconception of the two legal positions. The admissibility of evidence is no doubt a point of law, but once it is shown that the evidence on which the courts of facts have acted was admissible and relevant, it is not open to a party feeling aggrieved by the findings recorded by the courts of fact to contend before the High Court in second appeal that the said evidence is not sufficient to justify the findings of fact in question. It has been always recognized that sufficiency or adequacy of evidence to support a finding of fact is a matter for decision of the court of facts and cannot be agitated in a second appeal. Sometimes this position is expressed by saying that, like all questions of fact, sufficiency or adequacy of evidence in support of a case is also left to the jury for its verdict. This position has always been accepted without dissent, and it can be stated without any doubt that it enunciates what can be properly characterized as an elementary proposition. Therefore, whenever this court is satisfied that in dealing with a second appeal, the High Court is either unwittingly or in a casual manner or deliberately, as in this case, contravening the limits prescribed by Section 100, it becomes the duty of this court to intervene and give effect to the said provisions. It may be that in some cases the High Court dealing with the second appeal is inclined to take the view that what it regards to be justice or equity of the case has not been served by the findings of fact recorded by the courts of fact. But on such occasions, it is necessary to remember that what is administered in court is justice according to law and consideration of fair play and equity. However important they may be, must yield to the clear and express provisions of the law. If in reaching its decision in second appeal, the High Court contravenes the express provision of Section 100, it would inevitably introduce in such decision an element of disconcerting unpredictability, which is usually associated with gambling, and that is a recourse which judicial process must constantly, scrupulously endeavor to avoid. So basically, whether the evidence of the PWs and DWs put together was sufficient to sort of decide the question of adoption is not a question that can be raised. Now, if the factum of adoption cannot be challenged, then perhaps the first substantial question of law does not come to their aid, because that is again dependent on them showing that the factum of adoption was actually not proven.
To continue on Friday. Mr. O.P. Bhatti, counsel for the appellant, is present. Submission, due to positive, right, the submission of Mr. B.D. Deka, counsel for the respondent, remains inconclusive. Let's stop, give Friday. Just Thursday the ऊपर है.
Friday?
Huh? Thursday then, not Friday. Pardon me?
Yeah.
Yeah.
59, please. 29 future is having one more thing which was forest.
Oh, not 20, 29. 29 there is already a pattern, then 30. 30.
First February.
Ah, this, it will be first, right? So there is already a participant fixed.
1/3/24.
Because right now, in the division bench, I am engrossed with a continuous hearing of an appeal. And that is so voluminous that if I break it, then I will forget it.
And now the list also depicts for how many years the dealer.
We can't help it now. Well, in this case, the division bench matter, all the accused persons except one have already served out their sentence. If we delay it, it will not be good.